Article 14, the rule of law. Article 14, the state shall not deny to any person equality before the law or equal protection of the law within the territory of India. The first expression, that is equality before the law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privileges in favor of any individual. No man is above law. This concept is of British origin. The second expression, equal protection of law, directs that equal protection shall be secured to all persons within the territory of India in the enjoyment of their rights and privileges without a favorism and discrimination. This is origin from United States. It means that all persons should be subjected to the ordinary laws of the land equally, and no person, irrespective of his status, rank, and condition, should be treated above the law. Case law. Shiv Shankar versus MP government, AIR 1951, Nagpur 58. It was held in this case that equality before the law is a negative concept, which means absence of any special privileges in favor of any individual or class, irrespective of the status, rank, and office. It was also held in this case that equal protection before law is a positive concept, which would certainly mean that equality of treatment in equal circumstances. Exceptions to the equality before the law: first, president or governor of the state. They are not answerable to any court for the discharge of their duties and exercise of the powers within while in the office. Second, bar of criminal proceedings, president and governor. Third, bar of civil proceedings, both president and governor. Proceedings passed prior to the existence of the constitution cannot be challenged. And fifth one, foreign sovereigns and ambassadors. So this is nothing but regarding Article 14 and principle of classification. Article 14 of the Constitution does not prohibit classification. It only forbids a class legislation. For the purpose of permissible classification, two conditions must be complied with. First, the classification should be based upon an intelligible differentia or sufficient to distinguish persons or things that club together from the others who are left out of such clubbing. And second, the differential should have rational relation to the purpose and expected to be achieved by the act. Article 14 of the Indian Constitution, rule of law. The notion of equality before the law is a part of a rule of law concept. The Supreme Court ruled that the phrase rule of law in Article 14 is a basic component of the Constitution. The principle of rule of law was propounded by British jurist A.V. Dicey. Three elements are there. First, no arbitrary powers. There should be an absence of arbitrary power. That is, no man can be punished except for a breach of a law. An offense should be proved before the ordinary courts to punish a person according to a legal procedure. This is an application in the Indian system. Second, equality before law. Equality before the law is a subjection of all citizens regardless of class, that is rich or poor, high or class, official and not, to the common law of the state as applied by ordinary law courts. This is true for the Indian system. And third, source of individual rights. DC believed that there should be an enforcing authority to effectively enforce the above two principles. According to DC, courts should be the enforcing authority. The Constitution was created as a result of how the courts of law established and upheld individual rights, not the other way around it. It held that the court of law is the source of individual rights. This provision is not applicable in the Indian system as India has a written constitution which is the source of individual rights. Thank you for watching this video. Please like it, subscribe it, and send to your friends also. Thank you.